Hello?
Hello, is this Miss Nurfadila binti Ahmad Saikin?
Yes, I am.
First of all, thank you for your application. Your application for Guru Sanakan Tidak Terlatih position stand out to us, and we would like to invite you for an interview. The interview will be at Pejabat Pendidikan Daerah Hulu Lengan on 2 January 2009.
Thank you for your invitation to this interview. I will be available on that day. Okay, thank you.
Come in.
Hello.
Hello. Have a seat.
Thank you.
I have checked your resume and it's quite interesting. So, Miss Nurfadila, do you think that you have fulfilled our requirements to become a Guru Sanakan Tidak Terlatih?
Yes, I'm sure that I'm capable for this job.
Thank you for your cooperation.
I'm looking forward for your response.
Okay, we have done with our briefing. Before I end this interview session, may I ask who is pregnant here? Oh, you, Miss Nurfadila. So I have to withdraw your placement memo.
They did not accept me for this job just because I'm pregnant? It is unacceptable. I need an explanation regarding this matter.
All rise. The High Court of Shah Alam is now in session. Honorable Judge Ami Yusof is presiding.
Thank you. You may be seated. Court is now in session. We call Nurfadila binti Ahmad Saikin and Chaid bin Basirun and others is now in session.
Defendant, please rise.
Yes,
What is your name and your age?
my name is Chaid bin Basirun and I representing 5 defendants of the case.
You are charged for violation of Article 8, Clause 2 of Federal Constitution under the scope of gender discrimination. How do you plead?
I pleaded not guilty.
Is the plaintiff counsel ready?
Yes, my lord.
Is the defendant counsel ready?
Yes, my lord.
We will now hear opening statement from the plaintiff.
Good morning, my lord, ladies and gentlemen. First of all, my client has been revoked for her appointment as a Guru Sandaran Tidak Terlatih because she was pregnant at the time of the appointment. My client had received a memo on her appointment stating that she will soon be appointed as a GSTT and she have to attend a brief session to brief about the terms to be a GSTT. During the brief session, only then my client was informed that her appointment will be revoked because she is pregnant. The defendant act of revoking my client appointment is a gender discrimination in violation of Article 8, Clause 2 of the Federal Constitution of Malaysia. That's all from me.
Thank you, counsel. We may now hear the opening statement from the defendant to defer the plaintiff to rest their case.
Good morning, my lord, ladies and gentlemen. First of all, my client is presumed innocent until proven guilty. In 2009, my client Chaid bin Basirun was sued for violating fundamental liberties of the plaintiff accordance to Article 8 of the Federal Constitution of Malaysia.
Plaintiff counsel, do you need to call any witness?
No, my lord.
Plaintiff counsel, please present your case.
Much obliged. Plaintiff, in your present statement, you said that your position as a GSTT has been revoked. Is it correct?
Yes, I dare to say that my posting as a GSTT has been revoked and I got the notice right after I have been appointed. This is violating my right as a human according to our federal constitution. Just because I am pregnant mother, my position has been terminated? My lord, this is such a gender discrimination.
Plaintiff, stay calm or I'll give you a contempt of court.
My apologies.
Plaintiff, do you know or acknowledge that pregnant women cannot be appointed as a Guru Sandakan Tak Terlatih?
No. On the day I attended the interview, I was asked to fill up certain forms prior to the interview. During the interview, a question posed to me only included questions pertaining to my general knowledge, personal details, problem-solving skill, and residential address. On 11 January 2009, I received a text message from a PPDHL officer regarding my appointment as a GSTT, and I have to attend a brief session for my placement post. Before and during the interview, I was never asked whether I was pregnant or not. Furthermore, there is no notice at all saying a pregnant woman cannot be a GSTT.
Plaintiff counsel, do you want to add something?
Yes, my lord. The plaintiff's application to assert her right to a legal status was in line with Section 41 of the Specific Relief Act 1950. Further, the plaintiff had also satisfied the proviso to Section 41 of the SRA, in that she had not only sought declaratory orders but also damages. My lord, it is very clear that the contract for GSTT is a month-to-month contract and it can be terminated at any time. Even after 1 month of working, there is no guarantee that the person will stay working as a GSTT, even if she is not pregnant. As such, I presume there is no merit in the argument put forward by the defendant that employing a pregnant woman to fill up the post will defeat the purpose of GSTT to solve the problem of shortage of teachers in Malaysia. Even medical checkup for pregnant women will not disturb the school time, as medical checkup can be done in the evening or night. Hence, a declaration was a proper form of relief in this case. The word gender was incorporated into Article 8, Clause 2 of the Constitution in order to comply with Malaysia's obligation under the Convention on the Elimination of All Forms of Discrimination against Women, we call it as CEDAW, to reflect the view that women were not discriminated.
Counsel, but CEDAW is just a declaration from United Nations. How does it binding our law?
Thank you for your concern. My lord, it is settled law that the CEDAW had the force of law and was binding on member states, including Malaysia. In interpreting Article 8, Clause 2 of the Constitution, it was the court's duty to take into account the government's commitment at an international level. As such, there was no impediment for the court to refer to CEDAW in interpreting Article 8, Clause 2 of the Constitution. Applying Article 1 and 11 of CEDAW, it was found that pregnancy in this case was a form of gender discrimination. It was a basic biological fact that only women had the capacity to become pregnant, and thus discrimination on the basis of pregnancy was a form of gender discrimination. Hence, it was found that the plaintiff should have been entitled to be employed as a GSTT even if she was pregnant.
Thank you, counsel. I think I heard enough from you. Defendant counsel, please present your case.
Much obliged, my lord. The purpose of employing the GSTT is to help overcome the shortage of teachers and not to add the problem to the Ministry of Education. Employing a pregnant woman will cause a lot of problems to the defendant because of various reasons. The reasons may be: the first one, the period between the times of the delivery of full health is too long, which is 2 months. Second, a pregnant woman as a GSTT may not frequently to be able to attend to her job due to various health reasons. The third, when she gives birth, she needs to be replaced by a new teacher who will require further briefings. And the fourth, a GSTT post cannot be filled with replacement teachers.
But my lord, I am just in my first trimester, so it is impossible for me to give birth in the period of being a GSTT, which is only 1 month and could affect my job and my tasks.
My lord, may I apply a cross-examination towards the plaintiff?
Yes, you may proceed.
Plaintiff, do you know that your situation, i.e. pregnant, might give inconvenience to the defendant?
No, I am still with my stand that my situation will not give any effect to the defendants. In addition, my posting as a GSTT only for a month, and it is observed that it will give a bad effect to the defendant's side, in which my pregnancy is only 3 months old, and there is no any complication during that period that will affect my works as a GSTT.
That's all, my lord. Thank you.
All rise.
Please be seated.
The High Court of Shah Alam continue in session on the case of Nur Fadilah binti Ahmad Saikin and Syed bin Basirun and others.
We continue the trial with defendant counsel. Defendant counsel, do you want to add anything to support your submission?
Yes, my lord. Regards to my second submission, the plaintiff have no locus standi to bring this action, and the declaration is not a proper remedy to use in this case. It is our contention that there is no contract between the plaintiff and the defendant. Therefore, the plaintiff has not acquired a legal right as against the defendants to grant her the locus standi to make this application.